Chester Borrows.
Thank you, Mr Speaker, and it gives me some heart to note the tenor of the debate in respect of the issue currently before the House. And it seems to be that that tenor is that the damage has been to the public perception because of a perception that there was a conflict rather than any actual corruption found. And I agree with the immediate previous speaker who said that we must do all we can to protect confidence in our court system. And I want to recall to the House a paragraph from an article in the New Zealand Herald that speaks to this issue. And it states, some erosion of confidence must have already occurred because the primary facts of Wilson's behaviour, his failure to recognise immediately the extent of his personal and financial connections with a lawyer arguing a case in his courtroom, and to remove himself from the case raised serious doubts about his judgment. So do his failure to realise the grievousness of his mistake and fully account for his relationship with the lawyer and offer to resign should have followed, and of course we now know that it did. And it's a shame that it did, because by reputation we know that Justice Wilson did a lot of work pro bono for interest groups such as Maori to promote the interests of various iwi, and we need to respect him for the fact that he did that, as well as for the public appreciation for what he brought to the table in terms of his experience and his candour and the gravitas that he brought to his role. But it's important to make just a couple of points too in respect of speeches that have been made. One is the openness of the Acting Attorney-General, the Honourable Judith Collins, in respect of what occurred and what finally occurred by way of settlement. She didn't seek to hide that, and that has been a matter of public record. And so it is important then for the public watching on to note that openness and to what the expenses were to the Crown on behalf of the taxpayer. The other point that needs to be made is in respect to comments made, I think, by the Honourable Trevor Mallard, because comment was made that submissions should not have been filed by the Attorney-General, and in fact he should have had some other colleague file them for him. And for clarification, it's important to point out that the submissions that were made were prepared by the Solicitor General, and they stated the Crown's position in this matter, and they were only nominally filed by the Attorney General as a party to the proceedings. And so it is important to note that in these legal processes that the law is an unusual sort of an environment for lay people to get their heads around. And it does appear that when there is a conflict, or there is the appearance of a conflict, lay people are very quick to make leaps in their decision making as to whether or not there is an element of corruption. In other words, they're prepared to say that if something's smelly, then there's definitely something wrong. In actual fact, the different arms of government under the separation of power are loath to point the finger between them, because it's important that there is a remaining confidence within the people who have to live under the law, and so under the adjudication of one branch of the law and under the laws created and enforced by the other two branches of the law. Mr Speaker, I see no reason to go much further in this respect, other than to say that it is a sad day for New Zealand because of the loss of an esteemed member of the judiciary, but at the same time to recognise the need for that to happen, to preserve the perception of openness and integrity within our judicial system, is in fact making sacrifice in lieu of the greater good. That public perception that our legal system is above reproach is something that we must jealously guard and work strenuously as a House to ensure that we protect in the future. for the good of all New Zealanders. Thank you.
The time for